At Eltron, I mentioned up front that we are a fairly large and complex organization, and what the POPIA Act calls for is that if you need to delegate the authority from an information officer to a deputy information officer between operating companies, you need to do so within your organization in order to be able to respond to POPIA. So to springboard off what Debbie said, we have set that up within Eltron. We've got an information officer where we've got separate legal entities. We've got an information officer for those entities. And otherwise, where we've got divisions, we've got deputy information officers. Now, this team would not be able to work the way that they have and as efficiently as they have without the support of Hansi from a legal perspective. And Hansi, when we look at POPIA and we look at the response to it from a legal perspective, can you maybe share with us some of the discussions that are happening in legal circles in this regard to prepare for it?
Thank you. Thanks, Shane. So POPIA came and was gazetted in 2013, but it only took effect on the 1st of July in 2020, and then we had this 12-month grace period. So come the 30th of June, which Shane mentioned in 50 days, 51 odd days, all organizations must comply with POPIA. And the penalties of non-compliance is very severe and significant. We're looking at a 10-year imprisonment or 10 million rand fine. So it is extremely important then for us as a responsible organization to make sure that where we are the responsible party, process your information accordingly and lawfully in accordance with POPIA. So I just need to mention that where we differ from GDPR, which is the legislation applicable in the European Commission, is POPIA is applicable to natural and juristic persons, where in the EU, it is only applicable to natural persons. So as you can hear from that comment, the net is so much wider in terms of POPIA. And then it is also important to note that all natural and juristic persons domiciled in South Africa is obviously subject to POPIA, but also, even if you're not domiciled in South Africa, but you process personal information in South Africa, you might be caught up with POPIA. So that is one aspect that the let's call it the so-called POPIA legal nerds are grappling with at the moment, is the applicability. And that brings us to the next topic, which is obviously when are you a responsible party and when are you an operator? So you're a responsible party when you determine the purpose of the processing of that information. So a good example would be, and all of you are, employers. So when your employee provides you with data and you process that on your IT system, you're a responsible party. But where you outsource it to someone to do your payroll for you, then that appointment, a party is an operator. So the responsible party has got a lot of obligations, which is set out in the POPIA Act. And, you know, just to name a few of those aspects, there's 8 principles, but if you look at the accountability, the limitation on processing, the openness, the security, which is a very big aspect of it, and the other 4, that all we have put into our privacy policy. And that privacy policy is what is very important, and we have communicated that hopefully by now to all of you as customer and supplier, but also through newsletters, and it is available on our website. So that is very important to take note of. I think the other area that needs attention is the contracting side of things. So a lot of you might say, but do we need an agreement now with Eltron? So the answer is no. We don't have to go now and change our agreements unless there's an operating aspect and you are an operator, then we do need an addendum with you. or where we process special information or information about children, then we don't only need to have a contract in place, but we also need to get consent, which is required in terms of POPI. So that's very important. So you will notice that we have been sending out letters referring you to a privacy statement, and then obviously where there's a role that you fulfill as a operator, we would have addressed it with an addendum. And that's another area where there's a lot of debate, because sometimes you can be both. You can be responsible party or you can be operator. But yeah, Shane, I think we are going into a very interesting time, like we did with the CPA, the Consumer Protection Act. Obviously, in the beginning, there's going to be a lot of interpretation issues. The regulator, I believe, will obviously also issue a lot of regulations going forward. And obviously, there's lots of debate around the IPR also when it gets to personal information and, you know, who owns what. And that is also going to be a very interesting area of the law going forward. Thanks, Sean.
Great, thanks, Hansi.